ground that the division of the schedule is matured and in violation of the redress mechanism stated under the Physical Planning Act. On the same day, the applicant filed a notice of appeal and simultaneously brought a notice of motion dated 11 December 2018, seeking a conservatory order pending the filing of an appeal and or the filing of an application for exemption under Section 9, Subsection 4 of the Fair Administrative Action Act. That application is the subject of this program. The applicant contends that the respondent descended on the suit property last night with the bulldozer and the backbone demolition of the property. The applicant urges the court to conserve the property pending either of the two options. Its position is that only a portion of the property has been demolished. The respondent opposes the application. Its position is that what was before court was a judicial review motion, and the court having rendered a judgment, it is functional application. The respondent further contends that demolition has already taken place, and there is nothing to concern. I have considered the tenor and import of the application, and the parties rival affidavits and submissions. There is common ground that what was before court was a plea for judicial review order, and that plea was declined through a final judgment of the court. What would follow that is an appeal to the Court of Appeal. The applicant has exhibited evidence that demolition is ongoing. The court record shows that indeed the applicant filed a notice of appeal on 11th December 2018. It has been considered that the notice of appeal has not been served. Section 13, subsection 7 of the Environment and Land Court Act gives this court wide powers, including power to issue interim preservation orders. Because the applicant has demonstrated intention to appeal against the judgment of this court, a limited conservation order would, in my view, serve the interest of justice in this matter. Consequently, I will issue a limited conservatory order to remain in force for 7 days, during which period the applicant will file an appeal and seek appropriate interim relief in the appellate court. The material enforcement notice is accordingly suspended for 7 days from today.
Pursuant to your ruling of the afternoon of the 11th, which I recall was to the effect that there was no evidence of an appeal or an appellate process kicking off, and we moved you formally. A notice of appeal was duly filed the same afternoon, and a certificate of urgency was filed the same afternoon. The next day was a public holiday, Jamhuri Day, and only this morning, pursuant to the directions of your brother, did we come here. As to the question that the enforcement notice has taken effect and there is nothing to stay, my Lord, there is a constitutional aspect to that enforcement notice. There is the question of the right to and protection of property.
My learned friend should confine himself to the reply.
The question, the reply is this, my Lord. The contention was that the applicant has done.
The contention, there is nothing to say.
Yes. So there is a property, there is a development, there is a right, an inherent constitutional right to property and the protection of the same. We've demonstrated to you in evidence that there is indeed a lot to stay. The right to property subsists to this moment. As to whether there is a constitutional aspect to warrant the grant of a conservatory order, our contention and our reply is that the grant of in exercise of your jurisdiction, you are acting under your constitutional authority. You're exercising judicial authority as granted to you under the Constitution. And it is indeed the Constitution at Article 22 that gives you the right to grant, among other orders, conservatory order. As to whether there has been an exhibition of an intention of appeal, my Lord, the record will show you that indeed there is a notice of appeal before the court. As to the question of my swearing an affidavit, my Lord will note on the 11th.
Well, none has been served on us. That's our contention. We haven't even seen any yet. None.
My Lord, I am instructed that this notice of appeal has yet to be signed by the deputy registrar, but indeed the record will show that it bears the court stamp of the 11th. This has all happened in the last hardly 24 hours. The last contention, my Lord, as to whether I can properly swear an affidavit, I have not sworn an affidavit on any contested issue at all. I have put before the court and I've said in my affidavit, I'm alive to the fact that I should not delve into contested matters, and I have only put before the court 5 photographs that were sent to me, as I have said, by my client's employee. They are only to demonstrate the fact that it is not contested that a demolition is in play. My Lord, I urge you to uphold. As to whether you, lastly, my Lord, as to whether you are functus officio, certainly not, my Lord. Certainly not. You may have pronounced yourself, but there are ancillary issues that arise after your judgment, including the grant of some measure of protection under the Constitution. So, my Lord, you are very much in charge of these proceedings. And lastly, on the question of the enforcement notice taking effect, the law, as I understand it, my Lord, is that an enforcement notice is not equals to a demolition order. And the law remains, my Lord, that in the same way that you cannot, the law will not countenance an eviction without judicial sanction. The law will not countenance the destruction of property without judicial sanction. Let me return to the statement I made. You are very much in charge at this point. And the client throws itself and at mercy in the plea that you will exercise your discretion and inherent power in favor of conserving its property. That's all.
Tremendous respect. This is not a constitutional petition where conservatory orders are known, identified by way of legal notice number 117 of 2013. That is the Mutunga rules. Legal notice 117 of 2013 identifies the issuance of conservatory orders. This being a judicial review circumscribed under Order 53, there is no room for conservatory orders. Secondly, my Lord has been told as one of the grounds informing this please is that there is an intended appeal and or the filing of an application for exemption under the Fair Administrative Act. neither of these intended actions have been exhibited by this applicant. Neither. You don't have a notice of appeal. At least we saw none exhibited to the application. There's nothing. Nothing has been served on me as we speak in terms of the notice of appeal. The notice of appeal must be served on all affected parties. It has not been given upon us. At any rate, and this is more fundamental, no notice of appeal was annexed to the affidavit of the applicant. The third one, another friend, Mr. Marete, is the one who has sworn the affidavit in support. According to the practice rules, the advocate's practice rules, Rule 9 of the advocate's practice rules, it is forbidden of an advocate to swear deposed to contested issues. Contested issues should not be sworn to by an advocate. And this begs the question is, why, my Lord? Why did the ex parte applicants direct us shy away from swearing to any fact that is before you? And my Lord, I would like you to know very kindly, with respect, this motion was filed and dated the 11th of December, even though we were served with this motion today on the 13th of December. The fourth objection is that there is nothing to stay. It is common ground that the demolition, or rather the enforcement notice, has taken effect. If you look, my Lord, with tremendous respect, carefully at the prayers being sought, is that you stay, you stop the effecting of the enforcement notice. It has already taken effect. And my Lord, the degree to which now my learned friend says that you intervene, it is also contested. I refer you very quickly to paragraph 19 of the replying affidavit at page 3 of the replying affidavit. Paragraph 19. There is nothing left. And my Lord, this has not been contested by my learned friend. He has not said that, looking at this very quickly, I have decided then to file a supplementary affidavit to contest this. In other words, my Lord, what will you be staying? And yet the enforcement has taken place. The issue here, my Lord, is the enforcement notice has taken effect. The fifth point, my Lord, is that this applicant has come before you lamenting about the enforcement notice being implemented, yet this is a statutory obligation. Can you stop the county government from effecting what statute, in terms of the Physical Planning Act, has empowered the county to do? And the question that then you would have to address is, what provision of the law has this ex parte applicant pointed to you could properly invoke so that then the county is stopped from effecting what by law it is mandated to do? So you will be acting with tremendous respect of the jurisdiction of the law. Lastly, the ex parte applicant has not shown that indeed it did anything after we left court on the 11th of December. And my Lord, I refer you very quickly.
You did anything in relation to?
The decision you made on the 11th of December, that this year, that is the judgment. After you issued the judgment, my Lord, I confronted my client. I said, His Lordship has dismissed it was about 3:30. In fact, my learned friend was saying that, what can we, this is my closing remarks, what can we do now? And your Lordship put your pen down and you said, really, if you could talk or do anything, yes, I got outside here. I called my learned friends, my client's county secretary, acting county secretary, and I said, this is what His Lordship has said. Their apprehension is that you could move in. Say, let's wait and see. I refer you, these are my closing remarks, I refer you to page 2 of the replying affidavit. Paragraph 12 and 13. These are my closing remarks. Paragraph 12 and 13. This ex parte applicant did absolutely nothing. Nothing, my lord. No telephone call, no email, even to write through their advocate. Counsel, please, could we see how this should be or could be ameliorated? Nothing. So for them to say that there was a structure, a demolition, vehicle or machine on Jamhuri Day, it is contested. And there is absolutely no evidence that this happened because it is denied here by the respondent. They did not write anything. They did not even write to me or even email me or say that we would like to resolve this. Please, can you see to it that there is no effectuation of the enforcement? Can we see and see how? They did nothing. Now, at 12:30 p.m., they come to you, and at 1:30 p.m., we serve you this application for stay. In the morning is when the enforcement took effect. So there really is nothing. And what I can say, my lord, the ex parte applicant has itself to blame. A window stood open, never sees it, done nothing. What then can you do? The law is to be enforced. And so it was enforced. Had they acted with expedition and say that, look, can we have a roundtable meeting and see? My client would have been amenable to hear what they have to say. But for the notice to have taken effect is because they did nothing and it was dated December last year. The law took its course.